Okay, uh, welcome lawyers, advocates, law students. Uh, I'm making this tutorial for you people to understand how to begin with legal drafting. So previously I was giving these sessions online as well as training students who were working with me. So after a long thought that why shouldn't I do it online? This is going to be a pre-recorded video where you can watch this at your own convenience whenever you're there in the court or maybe working, or you get time to just scroll and see it. So definitely online convenience is there. So my effort is there to bring you up how to begin with legal drafting. That's one. Second, how to understand and draw a blueprint, that what all I need to know before I get fully equipped with the topic of legal drafting. Third, I've covered fundamental rules here as well. There'll be few of the basics checklist. I'll be sharing a free book with you as well. You can also find various books that are online available, so you can also get that. And then we'll be just showing you a few of the sample notes which I have compiled, legal notes. So this is going to be the session of fundamental rules of legal drafting course for you people. Now, I'll quickly begin with the fundamental rules. I believe you can see it on your screen at the moment. So let me just scroll it a bit. Okay. See, legal drafting is a practical subject. Believe me, you'll get it from this video? No. You'll just get to know the blueprint, the framework, the outline. And finally, after this video, you need to go back and start drafting it. So it's like swimming. Unless and until you don't get into the water and start practicing your strokes, you won't get it. So it is as simple as it can be. So you can have ample of formats from me. You can get it downloaded. You can keep it in your folder. But unless and until you start drafting single document every day, you won't get it right. So my advice to everyone out there who are starting off, who are already there as a practitioner, you need to take drafting as a daily thing, like we do meditation or like we eat, take a bath. So the more you draft, the more you learn about the intricacies of drafting. Okay. So this is my details. In case we have also doubt sessions, if you have questions for us, you can come to our office. We'll be more than happy to assist you. And sometime you might get a case to draft on. So that depends whether we are working on Saturdays or not. So this is for the students, law students, legal drafting course that have drafted. There is a master course as well. It is just an introductory video where you'll get to know the basics only. It is just the beginning of the course. So you'll probably get an idea that how the course is going to function or going to proceed from this video. Okay. Let me just take this one, how it works. Okay, this is, got it. Because see, when we are beginning off with our careers, we understand that our seniors won't have got much time for us to let us know how legal drafting works. So at that point of time, we sometimes feel lost actually. So that course is there for a medium where you people can actually start drafting it. You can start connecting the dots whenever you begin with your legal internships or practice. So the purpose of this online legal drafting course is very much clear. I'm there to help you out. I need to cut short your journey. Excuse me for a moment. Okay, so sorry for that. So my purpose is there so that whatever I have learned in 3-4 years, I don't want you people to know the same. I want you cut short the journey. From day one, you start practicing it right. You at least have a blueprint or a blue frame in mind. So that's the whole idea of this course. Now, the initial beginnings of a plaint, you might find it in section 26 of CPC. that institution of a plaint covers that presentation of a plaint in a manner. Then Order 4, Rule 1 of CPC shall instituted by presentation to the plaint in court such officer as an appoint. So that is a few legal technicalities. Just to, I believe everyone has gone through it, but to bring up here, just to know the initial findings, that where we see these drafting things. Then written statement, additional documents, the pleadings that we call, maybe a reply, a rejoinder. Okay, now this is from the law school that we have learned. We need to state only the facts, not law. So that's number one. You need not to tell a judge what the law is there, because he's already aware of it. You just need to tell him like how the facts that are there in the question constitute either an offense or an omission on the part of the respondent. So it's all about facts, not the law. Now there are exceptions, which is foreign laws. You don't have to state it. Question of mixed laws and facts conclusion, for sake of clarity and convenience you can state it. And presumptions, which is obvious that the proof of onus lies with the respondent only. So there probably you can just skip that part. And finally the custom or usages of trade, which hasn't gone the force of law, need not to be pleaded. So it's a settled thing there. Now the second aspect, material facts to be stated as per Order 6, Rule 2 of CPC. Now what is material? Which is relevant, which is connected to the case in hand. That's all you need to state. You need not to state anything beyond it. Otherwise it'll be a rough thing, rough exercise. You won't be able to shaft off the real crux of the matter from the waste. So that is why we say stick to the facts, materially relevant facts. Now exceptions, condition precedent. If a law mandates something, then it must be complied. For example, we need to serve government institutions first whenever we file a suit against them. That's Section 80 CPC. So that is a condition precedent. Even if you go to the court, you need to either file an exemption for it or you need to comply it first. Otherwise, court won't hear you. So that's one. Now, presumption shall presume, do not state, may presume, stated to the court in pleading. So shall is a dominatory word. Where shall says it has to be done, do not state. May presume, stated to the court. You can say it. Now matter of inducement, facts which state subsequent events can also be stated in petition. Mention facts, not evidence. Okay. Evidence has its own stage. Like after the filing of a case on the appearance part, the evidence stage will come. So you can hold till then there. You can bring on the evidence part later on. Facts required to be proved. Material facts. Factum probentia, facts by means of which they are to be proved. Particular evidence. Pleading should contain only factum probanda, which is facts that are required to be proved, not factum probentia, which means facts by means. I understand these are a few technical terminologies, but it is just for the sake of clarity. You won't be going to use it in your legal drafting and careers. It is just for the sake of clarity. So that's there. Now, this is a master thing to do. Be concise and precise and certain. That goes a long way in understanding legal drafting of the documents that we have. Okay. Now, further goal should be to attain brevity and precision. For brevity, omit all necessary facts. Omit all unnecessary details when alleging material facts. Proper attention to language alleging material facts. For precision, names should be correct. This is a very important aspect actually. People might say that we are going to use different names of a single person differently. No. You need to understand that's how a case is being drafted. You need to stay consistent with your story. So pronounce he, she, they be avoided. Do not refer plaintiff, defendant by names. They are either called respondent, defendant. This is how the terminologies work. You need not to pick names here. Okay. Refer them by same name throughout. Rest practice makes the man, woman perfect. It's a long practice saying that to know something really better in a good way, to master it, to hone your skills, you need to practice daily. So this is the beginning of this drafting course. Now I'll move you to the next file that I have on my computers. My contact details are always there for you people in case you have any queries regarding the course. Now let me just move on to the next thing that I have for you people. Okay, now this is about formal paras. Okay, why I say formal paras? Because they need to be there in all your petitions. Every petition will have these formal paras. Now this is a part of our legal drafting course that we do online, and for doubt session we have offline as well. So I'll quickly just skip the irrelevant part and move to the right one. Okay, before any case is being drafted, you need to understand whether that's the right court or not, and you need to mention it in your petition as well. So the jurisdiction is the first aspect. Whether it's a consumer case, whether it's a criminal complaint, or whether it's a suit for eviction, or it's a succession certificate case, every case in this India, there is a specific clause in the act, specific section, specific rule is there which tells you where a particular case is to be going to be filed, and regarding that you need to have an averment in your petition. So jurisdiction is a most important thing here. Now limitation, once again, you need to file your cases in a particular time frame. You can't sleep for 10 years and come to the court, look, I forgot it. No, these are things which are not there in our system. If at all there is a delay of 1 year, 2 year, 3 year, 30 days, 3 days, 4 days, there is a specific procedure under the Limitation Act, and then you have to cite the delay reason as well as the number of delay. So you need to have an averment regarding it, whether there is a delay, and if there is a delay, you need to move a separate condonation application. So it's a part of your pleading. You need to cite it, you need to tell it. Now, another most important aspect, number 3, court fees. Every case that you file in a court has to be affixed with a court fee. It can be different, like there can be a ticket for it, there can be a registration fees, like in RERA we have 1,000 rupees for all the cases, and depending upon the kind of a case, like for a suit for declaration there has to be a court fees, for a suit for a recovery there has to be a court fees. So you need to consult with your munshi or maybe your senior or maybe with the registry concerned that how much is the court fees for a particular suit, and then you need to have an averment regarding this in your case, that how much court fees is going to be there and whether you have complied it or not. There has to be an averment regarding this. That's a must. Now another disclosure that you need to make to the court is number 4, any previous case. So you need to tell whether on the same issue or whether on the same ground, whether you have filed a previously case or not. So you need to have an averment regarding this. It is a thing in law that you can't file multiple cases on one thing, that you have filed in district court, you have filed in high court, you have moved to the another territory, another state on the same thing. You cannot file multiple cases. It is an offense and court can take strict actions on you. So you need to have a pleading for this regard as well, whether or not you have filed a similar case on the same issue or not. Now the next is alternate remedy. So was there an alternate remedy? Like we have first even in criminal sections that I say, before moving to the court, we need to first approach the police station concerned. Then if the police is not hearing, then the SSPs, the higher officers, higher ups, and if at all the entire machinery is not listening to you, they're not handling your grievance, then the court comes. It is not the case that on the very first instance you can just ring up the bell and come to the court. There is a statutory compliance of each and every machinery of this legal system. So for that, if there was an alternate remedy, whether you have availed it or not, and if not, if there can be compelling circumstances, I don't say that you can't do it, but it's an exception. Only in compelling circumstances where there is shortage of time, the danger is so imminent, it is so quick that you're going to lose things, only then you can come to the court, otherwise not. So you need to have a specific clause for alternate remedy mention it in your petition, and then you can take it a long way across. Now, cause of action. See, there has to be a reason why you're filing a case. It's not that you suddenly wake up one day and then go ahead, let's file a case today. No. You need to understand everything is connected here. What was the reason this case is being filed, and legally covered reason. It should not be on your whims and fancy that you feel like doing it. No. There has to be a clear reason covered under law why a particular problem has arose now only and what has been done about it till now. So court should know the timeline, actually when was the first instant this problem occurred and how it had been followed. So the court goes into that extent to understand that why now you are coming to the court, what has happened so far. So cause of action is very relevant. Now miscellaneous. See, there can be so many things which can be covered under miscellaneous. There can be a compliance of a certified copy. There can be a compliance for a condonation application or stay application, or maybe you don't have certified copies of a particular annexure. So this comes with practice actually, but you need to move in proper application for it. So that is why I have covered this in miscellaneous. In case you're not complying with any other thing, there is interim relief associated with your case. You need to move an application for it. So these are the formal paras that has to be there in every petition. So now next time whenever you are sitting down and drafting your case, you need to understand these things have to come first. So again, I'm mentioning a few of the things which are the basics, the gist of the drafting. So whenever your senior says these paras are never to be omitted, it must be a part of your pleading. So suddenly one day you're asked to draft something and then you forget any one of these paras. It can hamper your filing process as well, because there will be objections definitely, and whenever these objections come, it delays the filing time. The case will be listed later on. So if a client is waiting for the case to get listed and to be for the preliminary relief, then these things suffer a lot. So if you go prepared to your office, you know these things, it is an advantage that they don't have to start you from ABC, because you have already gone through the basics of drafting thing. You just need to have the facts and you have the structure. So see the application of this legal drafting course, where it is coming. This course is going to give you a structure where you need to fill in your facts, need to fill in your application of law, and then boom, you're good to go. So that's how things work actually in legal drafting. So this is just one of the thoughts that I have for the first generation lawyers. They're the ones who really had to struggle a lot. They need a helping hand, or maybe someone who can be a torchbearer for them. So for them, it is definitely, I'm a first generation lawyer. So for me, I have to discover it all my own. I don't want everyone to go through that struggle. That is why these courses are there for to just cut short your struggles, and you give you an edge with the other competitive lawyers out there, so that you can quickly go ahead with the drafting thing. You can proceed with the legal aspect, that how good you are at the question of law, understanding laws, substantial law, and the application of it. So legal drafting is just an aspect of your practice, and if it is covered, I'm sure the next would be the court craft. How you go in the court, how you address to the court, how you put up your points. That is a different learning aspect. So I won't cover it here, but yes, I'll try in my coming videos, or if I can produce something of my learnings which is helpful to the student out there, I'll definitely do. So this is a formal para petition that I have for you people. Now I'll move to the next file quickly, because I don't want to waste your time. Every single time of yours is precious. Now let me move to the next file that I have in my computer. Okay, this is a sample course material. See, to my students, I always give these benchmarks to them so that they can refer it to it. If at all they might need an access to it, they might need to learn it or cram it, or they just need to benchmark with it. So these sample materials are sent to the students on their email. So let us understand, this is just a sample material, that how you are going to begin with your first draft. Now, at the top, the address of the court is there. The very top, in the court of Punjab and Haryana, in the district court, in the court of Chief Judicial Magistrate. The very first thing that we do is to address it to the right court. Sometimes a petition may go to the session, but we have mentioned district magistrate. So a little changes is required. But a professional lawyer, the professionalism comes from the way a case is drafted. Anyone can make it out or tell it out, that how competent a lawyer is from his drafting. That's how I believe. The drafts are very neat and clean, tidy, they're to the point, everything is crisp, they have covered it well, neatly formatted, and that's how it speaks about their work, that how much they are charging, how have they done it, because there are a number of lawyers, because it's a good field. Everybody wants to be aware. But the only differentiator is these aspects. They do it differently, they do it with focus, they do it in a very diligent way. And that's why courses like these come up. Now, full name of parties along with address and age is a must. So, again, you need to mention the complete name of the party that is there. Age is there for affidavit purposes as well. And age is also there in like High Court. We need to mention the age of a person in the memo. So, if you do something which is acceptable to all the courts, you won't have to remember it. That's how I say. So, if you follow a drafting standard of an High Court, the courts below, they are obviously going to comply with your drafting manner. So that's how I say the standard, the bigger the court is, the drafting standards are more high. You might get an application accepted below just from a handwritten note. But in courts like high courts, tribunals, it's a complete set. You need to draft it, you need to print out, you need to sign it, attest it, then only it goes. So follow the highest standards first, and then you need not to remember it. What works in district court, what works in session courts, what works in consumer court, no. So that's how I say it, but rest, it's all on your convenience, the time and the fees you are being paid for it. So it's always a resource, it's always a service. So you need to make out the money as well from it. Now, we know it that whether a company or an organization or a department is sued or proceeded against, it has to be through someone. You can't just call up a company, State Bank of India, no. Government department, water, electricity, no. It need to be through an authorized officer, director, managing director, or the CEO, whosoever is the concerned in charge. So I mention an authorized representative because there can be a different person who's handling it. So I don't want to make a correction or maybe an omission on my part. So I play it safe. I always say whosoever is authorized on the behalf of company to prepare, he must come up and then he should do it. Now next is supporting affidavit. Supporting affidavit should be there along with your case every time. Like in consumer, if the time limit, if the pecuniary limit is less, it might be accepted as a self-attested one. But yes, affidavit is a requirement and you need not to state false facts. Otherwise, you can be charged for it. It is an offense and you can be punished for it. So I always say affidavit should be done by the parties. No lawyers or munshi should do it. That's my take on it. Now, all annexures duly certified, signed by attorney. That's a practice procedure that we follow. All tribunals and High Court follows it. So just put up your signatures, write true copy, certified, signed, and put up your mark. That's it. This is a part of the course material that I provide to my students. You all will be getting it if you move to my advanced course that I have for legal students, legal interns, and lawyers who are struggling with their drafting thing. So this will add to their advantage. Like they don't need not to spend 2 or 3 more years to learn this craft. They might learn it in 6 months or 1 year. That's all I can say. So my course covers drafting for all the courts, be it consumer court, be it High Court, be it district court. We also cover tribunals like CAT, AFT, NCLT, DLT. So like I have filed, to my experience, cases in all the courts that I have here in Tricity, Chandigarh. So luckily Chandigarh is the city of lawyers. You name any court, you will get it here. You name NCLT, we have it. You name DRT, we have it. You name State Commission Consumer, we have it. You name RERA, appellate, RERA is there in Panchkula. Punjab, RERA is in Sector 18 Chandigarh. So that's the reason why city is blessed with so many lawyers out here. It is so, I would say, conducive for the law legal practitioner, because you get so many courts here out. So law is definitely a good vocation or profession for students out there who are studying law. Maybe they're practicing law. So you just need to hold on there, learn this craft, and then possibly once you are master of it, you'll start having the revenue side of it as well. Now, this is very important. Whenever you get the material from your client, how to begin? Like, sir, I don't understand. What is the structure? How should I begin? Whenever a client calls me up, he brings down papers to me, he has handed over to me. So the old school way is definitely the best way. You need to note down the entire sequence of events. I take handwritten notes personally. So you need to first of all understand what has happened, when it has happened, and till date what has been done for it. So if you break it down in a structure, it is so easy to tell someone point wise. So the more easy you make it for the court, you'll get a relief. It is as simple as it can be. So it's that is why I say the argument is like more of a storytelling. What happened, when happened, how it happened, and now what. So it is as simple as it can be. Don't make it look like a fiction that the court is there just to make it out like what is going on, what is happening. No, it is for you to solve that puzzle for the judge so that it is easy for him to give you the relief. If you make it more complicated, make it more confusing, that he is lost in his brief, no, it would take time. He won't be able to go through the entire file on place, and then definitely the time for the relief goes further. So make his job easier. Make your draft so simple and convenient that anyone can make it out in 5 minutes what the case is all about. That should be your goal. So now the very first thing, case details, facts, dates, what has happened date wise from day 1 to day last, timeline developments from start till date, issues involved, legal question, names of individual, address, age. Okay, see, legal question is what is the position of law on a particular issue. You need to understand it might change from day to day. It can be prospective, it can be retrospective, what it covers. So we need to do a research, you need to have an understanding of the law at that point, and then you have to address it in your petition. Now I've covered names of individual, address, age on the top. It is there. Supporting documents, mark annexures as per story. So whatever, as per your version of the story, as per your case, whatever things come first, mark it annexure in that manner. So let's say for High Court we use A1, A2, A3. For consumer we can use C1, C2, C3. So this is how it works. For respondent usually it is R1, R2, R3, be it High Court, be it RERA. But for petitioner, for plaintiff, for applicant, it can change. Somebody use it. There is no fixed rule for it. It is as per your convenience, but I go court wise. Like a particular court is like consumer court C1, C2. For petitioner, where I write petitioner, it's P1, P2. For an applicant, it can be A1, A2, A3. So you need to have a logic to it. That is how you remember it for a long time. You won't be confused that what is there in the annexures. Why should I name it differently? So then it will have a sense of purpose, that why you are naming it like this. Now, jurisdiction is a must. You need to understand whether you are filing in the right court or not, limitation, appropriate forum of the cause. Most importantly, figure out relief prayer of your cause. What is it that you are asking the court to do? What is it that you want? So you need to tell out in the last para of your petition that in the end, this is all I am seeking. Give me this relief and my case is done. And you need to understand it. It's only once you can do it. Otherwise, you need to amend your prayers. It's a whole lot of an exercise. Then again, an amended reply will be filed. So like we take it in an actor's cut. You need to do it right in the very first go. You can have revision sessions of your petitions, but once it is there in the filing registry, you can't roll back. So whatever is filed, you have to stick to it. You have to stick to the tail. You have to stick to the version which you have written. So ask your client, conclude your prayers relief the best you can, because there cannot be a second chance for it. Okay, once notes are prepared, stick to the format quote-wise. As I've told you, you understand your story, you understand your case, and then it's a quite easy task for you to understand. Now, there should be a consistency from first day to last day. You should not mix too many thoughts, too many ideas in your paras. It should be one thought per para, so that everybody knows what happened in the first para, what happened in the consecutive, what happened in the further paras. So it has to be a gradual exercise. You can't mix so many thoughts together, because when you'll be reading it for your revision, you'll be walking it through that how things are happening para wise. So you need to understand and tell the same to the judge. So if you're not sure about yourself, you're jumping back to the idea 1, idea 2, idea 3, idea 4. It is same for the judge even. He won't be able to understand it. So consistency is a must thing for do. Now again, drafting sequence. I have mentioned it here. Outline. You can make an outline of your case. Get summary of the case, but it should not be vague. It should be relevant, precise, and coherent. Again, we have learned it in our previous document as well. The chronology or arrangement of facts should be in sequence. One para should speak of one point only that I've just shared now. Prefer use of simple legal language without use of heavy jargons, metaphors, making it less comprehensible. Avoid repetition. It's of no use. Know the formatting style, front margins of your quote, right, left margins of each quote. See, every quote has a particular format, font decided, how much space is to be left on the top, on the bottom, right and left. So you need to know it before drafting it. Either your munshi or maybe your senior, or you can go to the court website, what has been accepted so far. I follow the High Court, so it is easy for me. So you might get it for once and either save it in your notepad, computer, or email, so that you remember it, how the format is there. Because if you go it wrong after printouts are taken, then it becomes a huge, humongous task. Then it's a quite waste of the money even. All the pages are wasted, gutted. You need to print it again do the drafting thing, and possibly it will you'll lose time. What I mean to say is, so know the format for your case. Don't mix it up. Numbering of pages in sequence. You need to number it correctly. The numbers should be gradually increasing, and for the annexures as well, you need to understand this. Now, space between paragraphs, double space, is it the accepted one? You need to use double space only. That's how it works. Address the parties by name in petition, rather use the same in memo of parties. So you understand, you need not to take names in your petition. You always address it like respondent, defendant. You don't take the names in your petition. Now, the draft should spell the correct interpretation of law in backdrop of surrounding circumstances. So the position of law on your issue, that should be elaborated. So this is all about this file. Now the master line is, the more you draft, the more you learn. There cannot be any shortcuts. It has to be a real work from your hand. The more drafting you do, the more documents you make, the kind of a documents you make, the more you'll be confident about it. It's an art. That is why it needs a practice. So again, that's for my courses which I have compiled for my students. Okay, must we have one word for group of words, short sentences, mention time period, active over passive, write facts and narrative, lead it to the conclusion. And what we should not do not confuse our reader with all the facts in one para. Most of the people I see, they want to have a paragraph of 1 page, 2, 3 page. No, have a 5-6 liner paras. Break it down, make it more smaller, conducive. Don't have one page or 2 pages paragraphs. It's very difficult to read that long in one breath or one go. So avoid that thing. Now, repetition of facts, don't do it. Unless it points to a new thought, don't do it. Wrong provision under which case petition is filed. Very important. The case goes out of the court. If a wrong provision is mentioned, it is not acceptable. Registry will either refuse it or it will go on the very first date. Consistency narration of the sequence from day 1 to day last. Again, I say you need to understand it should be a consistent exercise. State facts, not law in your petition. Now, in my even this sample course material, you'll get an entire checklist. Every time you go and sit back to drafting, what should be there in your petition, what should not be missed, formal paras, signature at the bottom, verification, index, naming of the annexure. So see, this is just a checklist which you'll get it, but most of it I have already discussed. It is just you need to know the application of it while we are going to draft it in a full-fledged course, when we'll be making drafts for consumer court, RERA courts, or maybe high court, district court. All of these things will be covered, and then possibly you can make it out. Look, sir mentioned at that time. That is how it is being used. Now, judgments, how you can quote judgments in your pleadings, in your petitions, in your replies, in your rejoinders. For annexures, true copy, advocate, no affidavit for minor. See, this is how each and every minor thing I have covered it in my course. That even for a minor, you can't just file a case. It is a rule. All minors should be through a guardian only. Now, companies are sued through someone, you need an authorization. So this is a good amount of a checklist that I have prepared for you people. Whosoever is willing to go for a full course with me, he will be getting access to all of these materials, despite of the fact that he'll be also knowing the drafting of cases, real time, all the cases that I'm going to draft. He might join me, he might see how an actual case is being drafted. So this is a drafting checklist. Now, I have compilation of the books that we see online, so you might be able to get an access of these books. These are the course material. You can also do an online search and get it. But yes, whatever I have for my reference, I'll be able to share it with you people. Now, I have compilation of my work. There can be few of the legal notices or drafts which I'll be sharing with you people. You can get access to it. There are so many of the legal documents that I have. I'll just quickly skip it so that the content of the party doesn't come up. Now, for salaries, there are many legal notices that I have in my folder. So the best possible exercise is you people have at least an idea, fair idea how things are working in courts, how you are able to draft things. So that will give you confidence. The more you will draft these things, I'll be sharing these files with you people, and then possibly once you get access to these files, you can just put it on your computer, start drafting it, give time to your drafting skills, at least sit for an hour, so that you can at least draft one single document every day. And then slowly, with the passage of time, you can see this month I drafted 30 documents, 40 cases. What kind of a cases you drafted? Then at least your folders will be there. You can start drafting quickly. You'll have confidence. And further, this is to me actually personally what I say. All cases that you draft, when you go in the court, you remember each and everything. So you draft it in a manner you don't have to remember it for the entire passage of the this course time. You'll remember it, how the case was given and how it has been filed in the court. So that is an advantage actually, just because the more you draft, you know actually the law and the entire case, what has happened, how it has happened. I remember this has happened in this case. So this is actually a good thing actually. The more you draft, the more you know about your case. You don't have to remember it. Like there are lawyers, senior lawyers who don't draft it, so they have to go through the file. They have to remember it. They ask for notes because most of the time their juniors draft it. They read it, they break down the points and all. And that is the reason, because they have to do it many cases per day. They can't draft it on their own. And that is the reason, like in a beginning part of your career, if you draft it more, you draft it correct, you'll know about the case. Even for the arguments time, you can just go ahead and argue it. You don't have to refer to the file that long. Just in 5 minutes, you'll be able to remember that, look, this was the case and this has happened here. So this is the advantage of this course. So this is my video actually for the law students out there. I hope my effort, my exercise to bring you people to the basics of drafting in this this 40 minutes masterclass has been sufficed. And I believe, do leave your comments for me and do share your feedback. My number is there on the folder, on the file that you have seen. I'll just quickly share it. This is my number. This is how you can reach me if you want to go for a full-fledged course. It's going to be an online course, and whosoever who are based here in Chandigarh, we can have doubt sessions on Saturdays. So if you have some quick queries for me, you can come down to my office, but do give me a ring before coming, because we have a doubt session where I pull in every student whosoever been pending on the list. So I bring him up and quickly draft it. And also, whenever I have a real-time draft, I have a case to be drafted, so I take that brief and then bring on the students that, look, today we're going to draft a case, please come to our office, and you can see it live how cases are being drafted. And further, this is a 1-month course, the legal drafting course. It is a one hour on alternate days, so Monday, Wednesdays and Fridays. That is how it works, 3 times in a week. Because see, you need to understand, this is a practical course. I cannot teach you more theory on it, because it is just the structure. It is just a framework where you need what to place where. So in these practical courses, a good theory, maybe a list of bundles of PDFs, it won't help you. You need to understand, you need to have an accessibility of tools where you can look, I know what all needs to be there. Now I just need a live case. I need a live FIR. Where FIR comes, I can quickly draft a bail application. So this is how it works. You need a situation, you have the access to the tools, you have to access to the framework, and you go and draft it. So that is the benefit of this legal drafting course. So it's a 1-month course, alternate days, 1 hours. I usually do it early mornings or early evenings, because at daytime I'm at court. It's difficult for me, but yes, it is going to help you a lot in your legal drafting basics. So the price of the course will be, full-fledged course is 7,000 rupees, and you'll be able to get access to a good number of drafts for each courts, like be it district courts, be it high courts, be it RERA. So I'll share you an ample of drafting documents, just to keep it a benchmark for yourself, so that next time whenever you go and start drafting it, you'll know what all should be there. And last would be, the more you practice it, the more, because you can have any files from me, but unless and until you practice it, it is of no use. It will remain in your email, it will remain in your folder, and it won't be helpful to you. So do an honest thing to yourself. If you're paying me, if you're paying for this course, just go back and whatever document has been shared by me, just open up your computer, open up your Word file and draft it. Start drafting it. It's more of an action. It's not about thinking strategy. No, legal drafting is an entire practical course. You need to make drafts. You need to have a compilation of your drafts, structures, everything in place, so that whenever a case comes to you, you know how to break it down, how to begin. Because I believe I have many friends who take long time, like one week, 2 week to draft it. Ideally, I should say with time, it should be 1 or 2 day only, because second day is of the revision, just the facts are correct, the drafting and the pages, all everything in order. So because I want you to give time to your research also. If you just want to complete it in a day, it can be done so. But a good lawyer will always second check the facts. He'll always see the latest judgments on the topic, and that is how the best work comes in. So I believe this exercise of bringing you to the basics of legal drafting has some fruits for you people. You might have enjoyed watching this video, and do share your feedback. I'm there on LinkedIn, I'm there on Facebook, I'm there on Instagram. You can just search LegalSeva. That's the name of the website that I operate. My all experiences on different legal topics are mentioned there. You might try to see it, you might try to apply it, and then finally, if you find this course interesting, helpful, the number is there on the screen. You have any questions, I'm there to help you out. You might give me a buzz. I'll reply back to your queries, because during the course time I may not be able to pick, but yes, I'll apply. So thank you so much, everyone. Thank you so much. Thanks for watching.